Hello and welcome to Connected With Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. This is the 5th episode of the Latham & Watkins drug pricing series, and I'm Chris Schott, a partner in the healthcare and life sciences practice in our Washington, D.C. office. I focus my practice on manufacturer compliance related to the Medicaid drug rebate program, Medicare, and the 340B drug pricing program. Joining me is Danny Machado, an associate in our Washington, D.C. office.
Hi, Chris. Happy to be here.
Today is the first time we have a guest on our podcast, and we are very fortunate that Lynn Robson from Therapeutics is able to join us today. Lynn, do you want to introduce yourself?
Sure. Thanks for having me, Chris and Danny. I'm a graduate of Wake Forest Law School and University of Pennsylvania. Go Quakers and Demon Deacons. I began my career working in a law firm and then moved into a career that included several different stints in different areas. Business, compliance, legal roles, but all in the market access area. I worked for a couple of HMOs, Blue Cross Blue Shield in New Jersey, then moved into pharma and medical device legal roles at J&J and Stryker and several other U.S. and ex-U.S. based companies.
Thank you for that, Lynn, and thank you again for joining. In each episode, we focus on a specific drug pricing topic, and after discussing the substance, we ask the question, which Olympic sport is it like? And we have the list of Olympic sports here to see which most resembles the topic in terms of strategy, complexity, or frankly, level of conflict. So Danny, what is our topic for today?
Today we're going to be talking about the OIG compliance guidance. OIG stands for Office of Inspector General, and this compliance guidance is for the pharmaceutical industry that was published back in 2003 in the Federal Register.
So why would a manufacturer care about these guidelines today, Lynn, when they've been around for 20 years?
Thanks, Chris. Let's just step back for a minute. If a drug manufacturer would like its products reimbursed by Medicare and Medicaid, the manufacturer has to participate in several federal programs and sign several federal program agreements, like agreements under the Medicaid Drug Rebate Program, 340B, and Federal Supply Schedule. Both the programs and agreements subject a drug manufacturer to a number of laws, so it makes sense to set up a formal framework to reduce the likelihood of a problem, like a problem related to non-compliance with those laws.
So setting up a compliance framework, like a compliance program, can obviously help avoid problems. And we have as one source the OIG compliance elements, which we're talking about today. But let's not forget there's another source as well, and those are the reasonable assumption. And that is something that's embedded in the National Drug Rebate Agreement, the contract under which manufacturers participate in Medicaid. And it's an important safety valve that allows manufacturers to essentially fill gaps in the legal regime and still report in a compliant fashion. So Danny, tell us a little bit about OIG and its role and how that fits in with the guidance.
Yeah, so in 2003, the OIG issued compliance guidance. And to remind ourselves, OIG, or Office of the Inspector General, is the part of Health and Human Services that handles enforcement against manufacturers, among other agencies. So again, the question is, why is the 2003 guidance still relevant today, and what does it say?
Well, the OIG issued the compliance guidance to the pharmaceutical industry to let manufacturers know what the government thinks about fraud and abuse risk, along with the steps that the government thinks manufacturers should take to ensure compliance with laws. In a nutshell, the OIG compliance guidance recommends that a manufacturer have in place the 7 elements of an effective compliance program. The OIG's compliance guidance importantly talks about 3 areas of risk. 2 of those areas are areas that most compliance professionals are very familiar with: drug samples and then kickbacks and other illegal remuneration. The first area, and our focus for today, is the integrity of data used by state and federal governments to establish payment amounts or reimbursement amounts. In the guidance, the OIG specifically calls out the Medicare and Medicaid programs, so we can infer that the government would like to see that a manufacturer has in place a government price and compliance program with those 7 elements. Chris, I know you've read the OIG's guidance. Can you tell us what the 7 elements of an effective compliance program are?
Right, and it probably kind of helps to put them sort of under a couple of headlines, right? So I would say the key headlines here are focus on documentation, focus on having communication in the organization with the relevant stakeholders, and then having a workable, effective flow of information to the stakeholders. And so maybe with those sort of headlines to think about, we can quickly run down the 7 elements, and they begin with first, having written policies and procedures; second, having a compliance officer with the compliance committee; third, conducting effective training and education; fourth, developing effective lines of communication; fifth, having internal monitoring and auditing; sixth, enforcing standards through disciplinary guidelines; and then finally, the 7th element, responding promptly to detected problems and undertaking corrective action. So we tried to kind of group these together under these more real-world headings of documentation, communication and flow of information, but all this still is pretty abstract. So what kind of sources do we have or indicators of how OIG would expect these elements to be implemented in practice?
Yeah, thank you, Chris. I think we can look to enforcement action and settlements in the government pricing space. If you go to the OIG's website, so oig.hhs.gov, and click on the compliance tab, then click on compliance resources, you'll see a resource called corporate integrity agreements. CIAs are an agreement between the OIG and manufacturers that have been involved in some allegations of wrongdoing by the government under a variety of Civil False Claims Act statutes. In return for the OIG not seeking to exclude the manufacturer from participation in Medicare and Medicaid, the manufacturer agrees to obligations contractually in the CIA, and it's usually for a period of 5 years. If you do a search, you can pull up some CIAs that deal with government pricing. What you'll see is that the government in those government pricing related CIAs requires the manufacturer to agree contractually to implement or maintain a government price and compliance program, which includes those 7 elements, Chris, that you just talked about. Notably, importantly, scarily, some of those CIAs require manufacturers to do more, like have their board members personally do some sort of certification related to government price and compliance.
Yeah, and that reminds me of a quote from one of our colleagues, Sharon Small, over in the Novartis legal department, where she at a recent conference kind of said, you want to be the architect, right, of this infrastructure and not have the government design it, because if you let the government design it in the shape of a CIA, then the government will also live in it for 5 years, because, Lynn, like you said, oftentimes these agreements run for 5 years and maybe even longer. So in addition to being in control of your own compliance program, what's another benefit of having a compliance plan in place in case there were to be an enforcement action?
Yeah, let us remind ourselves of the history. The 7 elements of an effective compliance program actually come from the U.S. sentencing guidelines. Those guidelines are what the U.S. government uses when sentencing defendants. The guidelines contain both mitigating and aggravating factors. So to state the obvious, if a manufacturer finds itself in this position, it can potentially be beneficial for that manufacturer to have mitigating factors, like an effective compliance program.
The bottom line, Chris and Danny, is that where the government alleges there's a government pricing problem, if the manufacturer has an effective compliance program in place, this would be a mitigating factor that the government should consider when it comes to the penalty phase of an enforcement action.
Well, Lynn, I think that nicely sums up our topic for today, the importance of having compliance with these 7 elements and the benefit that it can give to the organization. So with that, then let's ask the question we announced in the beginning: which Olympic sport is it like? So Lynn, do you want to start?
Sure, this is probably the most fun part for me because I really like sports. So I'm going to have to go with a new sport for the Los Angeles 2028 Summer Olympics, and it would be lacrosse. And a big shout out to my former physical therapist, Beth, for reintroducing me to lacrosse, which is a fantastic sport. So to have a good lacrosse team, to score a lot of goals and give up few goals, it takes a team of skilled and interconnected individuals and functions to exploit opportunities and avoid pitfalls. The same goes for a government pricing compliance program. Your compliance program is the goalie, the backstop of an effective compliance program, while the players are the others who impact compliance. And that would include your commercial contracting and pricing operations. A fluid, adaptable, informed, fast-paced, and symbiotic team wins the game.
That's honestly very interesting, Lynn. I like this imagery a lot. Personally, I thought of tennis. Now, I've been playing tennis my whole life, and one thing that coaches consistently tell their tennis students is the need to have good equipment. You need a good racket, you need good shoes. Of course, this means spending a little bit of cash on the front end, but the reality is no matter how good a tennis player gets, you can have a great serve, a great forehand, great slicing, great volleying skills, you name it. If you don't have solid equipment to rely on, you're not going to be playing the best game you can. Thinking about the 7 elements of compliance that we were talking about earlier, it seems to me that they are kind of like having solid equipment for playing the best tennis that you can. Chris, what sport were you thinking?
Those are interesting choices, but for me, I would have to pick Nordic combined, and that's because we're about to enter winter, so my mind is in the winter mood. But also, Nordic combined is a combination of ski jumping and cross-country skiing, and those seemingly very different disciplines really kind of fit here for me into this picture, where on the one hand, we want to do ski jumping and fly high and soar in our drug development, in bringing innovative treatments to market and fostering patient access, but at the same time, we have to be mindful that combined with that is cross-country skiing, but we're going to be very slow and meticulous and carefully placing each step as we traverse the cold and hostile landscape that we have to get through. So Lynn, here at the conclusion of our podcast, where are we going to go? Where's the after party?
I mean, it seems like an obvious choice, Chris, that we're going to go to Hawthorne and Wood, which is in North Carolina, where UT is based. They've got a fantastic chef in front of the house, plus just down the street we have UNC Chapel Hill. Go Heels!
Thanks to Lynn for joining us from United Therapeutics, and thanks to Danny for being a moderator.
Thank you, Chris, and thank you, Lynn. It was great chatting with you both today.
Thanks for having me, Chris and Danny. Let's go to the after party.
And thank you to our listeners for checking out the Latham & Watkins Drug Pricing Series, which is part of our Connected With Latham podcast. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or anywhere else you listen to podcasts. If you have questions or would like additional information, please email us using the links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.